we
That strikes out your.
No, I'm up. I'm going to do that. I'm going to do that. Yeah.
we had pending the Stupak amendment to Title III, and we asked that it be pulled back until we can get a ruling from the parliamentarian as to whether it is germane to the bill. The parliamentarian advises us that because of the breadth of the bill, encompassing so many different titles, that this amendment would be germane. So therefore, the point of order is overruled. The amendment is pending before us, and Mr. Stupak has given an argument in favor of the amendment. Does anyone seek to be recognized in opposition? We'll go to Mr. Barton first, and then others will have a chance to speak.
Well, first of all, Mr. Chairman, before I speak in opposition, I do want to compliment you on actually checking with the parliamentarian. I appreciate that. Because of the scope of this bill, apparently, if EPA wanted to regulate ham sandwiches, that would also be germane to this bill. But having said that, let me get to the heart of this. First, I want to ask a question to the author, Mr. Stupak, because I know how hard he works as oversight chairman. This Section 359, do you intend it to apply to the CO2 market that this bill sets up, or are you simply trying to get more authority for the natural gas market that the FERC definitely has authority in currently?
The intent was to get to the carbon credit market because that was basically go to the carbon credit. It is both. So we're making it uniform across everything.
So how would you blend FERC's authority versus the EPA's authority?
Because when you come to regulating the exchanges, it's going to be the Commodities Future Trade Commission and FERC, the Federal Energy.
So you're not worried about creating a conflicting regulatory entity problem?
No, because I don't see EPA trading on the markets for carbon credits.
Okay.
And underneath the bill, FERC and them will set what allowances are allowed. We can release allowances in case there's spikes, so that's where FERC would have to play a role, along with the.
Well, I'm reclaiming thank you for answering my question, Mr. Stupak. I'm troubled that we're going to give new authority to an entity that has normally been in the wholesale market and the pipeline siting market and the electricity transmission siting market and interstate commerce. But setting that aside, I would call members' attention to line 9 and 10. It gives the FERC the authority, if they see that an entity may be violating, which would be present tense, may have violated, past tense, or may be about to violate, future tense, any provision of this act. This may be about to violate. If you take that to a common example, if a police officer thought we might be about to go past the speed limit, they could give us a ticket. I mean, that is very troubling that we're about to give the FERC the authority to go in and give these cease and desist orders based on their judgment or their intuition that somebody might be about to violate a provision of this act. So I'm very troubled by this, and I would hope that we would, if not defeat the amendment, encourage the author to at least delete that phrase, may be about to violate, because that, to me, is a very troubling
Would gentlemen yield on that point?
Be happy to.
On 9 and 10, that is the same authority that the Commodities Future Trade Commission has right now and Securities Exchange Commission. That's what happened in Amherst. If you have to go prove your case in court, which takes a lot of time, then the assets they may have, like the $291 million fine that was levied on Amherst, they sold their assets off. There's nothing left. By the time the case is adjudicated, there's no assets to go after. So if you believe there's a violation, you go in and get a cease and desist. It's no different than any other court proceeding where you go in and get an injunction that you do not dispose the assets until the case is resolved. Well, so there's a due process clause in here, because after that order is put forth, you have 10 days to get to a judicial court, U.S. District Court, to lift that order if it's erroneously done. So there's due process there all the way along, and it's no different than what we've been doing for years under SEC and the CFTC. FERC never had this power. This is the power they asked for, even when President Bush was, Mr. Kelleher, I think his name was. You know him pretty well, Mr. Barton. He was the guy who came and asked us for this.
I don't believe he asked for maybe about to violate, but I could be wrong. I don't want a police officer coming in my home and arresting me because that officer thinks I may be about to violate some statute.
But in order to arrest you, he has to have a warrant or some kind of review, and even in this case, there's a review provided.
Well, my time's expired.
Gentleman's time has expired. Chair recognizes the gentleman from Texas, Mr. Green.
Thank you, Mr. Chairman, and I think that my good friend, and really a good friend from Michigan, on what he's trying to accomplish is a great goal. He wants to prevent market manipulation in the energy commodities market, and that's laudable, and I agree. My concern is solutions is too broad and gives much unchecked authority to Federal Energy Regulatory Commission that we don't know what that they have the capacity to do it. But briefly, the Stupak Amendment would greatly expand the authority of FERC to issue cease and desist order for any violation or threatened violation of any provision, Natural Gas Act, Natural Gas Policy Act of 1978, and the Federal Power Act on its own motion without notice or hearing, without direct or immediate judicial review. FERC has existing authority for injunction authority that I would hope that we would at least let's see how they do that with this expanded authority we're giving them in this bill before we give them this authority. The amendment also would empower FERC to freeze the assets of a company under investigation for violations of market manipulation rules, also without notice or hearing or without direct immediate judicial review. For example, the amendment would allow FERC to issue a cease and desist order without notice and opportunity for a hearing unless the Commission determines that notice and hearing prior to entry would be impractical or contrary to public interest. The problem is the Commission itself makes that determination when to waive the notice and the opportunity for hearing requirement. The amendment limits the opportunity for immediate judicial review of the Commission action, which suggests that FERC could act without adequate judicial oversight. FERC has existing authority to ask a district judge for a TRO, or temporary restraining order, in situations, and I haven't heard anybody complain about their current authority is insufficient. And I don't disagree with the concept, and we tried to work out some language in the last 30 minutes, but we haven't been able to, and that's why I think this amendment is way overbroad for what we may be looking at. We're literally shooting in the dark, and those folks who don't understand it, you don't know what you're going to hit. And that may be that's my concern about this amendment. And I'd like to continue to work, and in fact, I'll yield to my great friend from the Upper Peninsula.
Well, I thank the gentleman, and you've always been a supporter of the Pump Act, and you've helped us with it, and you've been involved in all the hearings. The insufficiency, it's not insufficient because, again, Commodities Future Trade Commission has this authority, SEC has this authority. The reason why it's insufficient because FERC never had the authority. We're giving FERC the authority not only to do natural gas, but because we're creating a whole new market, the carbon credit market. I would rather, if we're going to create this whole new market, let's do it where we have robust regulation, not let the horse out of the barn and try to put it back in after. And for judicial review, if you go to page 4, 10 days after respondent was served with a temporary cease and desist, they can go to a U.S. District Court and do it. So judicial review is there. Same authority CFTC has, SEC has. FERC's never had it. They've asked for it. We're creating a new market. Let's have regulation and oversight over the new market so we don't create a nightmare like we've seen in the financial markets with energy, and that's the reason why we need this amendment. And I'll continue to work with the gentleman. If there's some accommodating language we can find in looking at CFTC and also SEC language, I'm happy to do so, but this is pretty much pattern after it now.
I will claim my time, and FERC has existing injunctive relief authority under Section 20 of the NGA, Natural Gas Act, Section 504 of the NGPA, and Section 314 of the Federal Power Act for all violations of these statutes, and there's no reason why this existing authority, which the Commission has rarely used, is inadequate now, and that's my concern about the amendment. And again,
if you yield, I don't disagree with you, but it's after the fact. You have to go through the litigation. You have to find a violation. Then you can go after it. What we're saying is, if there's a violation, stop it, freeze it, stop the action so we can protect the ratepayers and the U.S. taxpayers. Then, if there's violations, then at least we have some assets to go after. Amherst, $6 billion. What do we get for it? $291 million fine. What do we get? Nothing. They dispose of all the assets during the litigation.
Well, I run out of time, Mr. Chairman, but if my colleague would, well, he's already used his time, but again, the person is violating or has violated any of the provisions of the Act, there's already a current statute on that. But
Gentleman's time has expired. Are there any other members seeking recognition? The chair recognizes the gentleman from Florida, Mr. Stearns.
Thank you, Mr. Chairman, and strike the last word. I sort of feel like Mr. Green from Texas, what he indicated, that he has some apprehension about this because it's so comprehensive. You know, Mr. Chairman, this is an example where we should have had a hearing on this. Mr. Stupak and I have talked before about the lack of regulation and the worrying about this new market and what this means and the possibility that there'll be no regulation of this new market, which will have the same problem that we've seen in other markets, weak. But I think what the gentleman from Texas is saying, it's so encompassing, and here we are in a hearing at 11 o'clock at night trying to put in place a structure which is so encompassing that a lot of us are a little concerned, and I think it'd be worthwhile to have a hearing to get it right, because this new market, Mr. Stupak, you're talking about, it says if the Commission finds that any entity may be violating, may have violated, or may be about to violate any provisions of this Act. Now, this Act is 1,000 pages. Well, I guess this applies to the Natural Gas Act. Okay, to violate any provision of this Act, or any rule, any regulation, any restriction, any condition. So if you violate any condition, I mean, that seems, I don't know where you got this language. Maybe this is standard legal language that's used in this kind of thing, but for them to come after you, a cease and desist order based upon any condition, any regulation, or any restriction, an order imposed as cease and desist, it's just a little bit overwhelming, I think, for a person just to suddenly get this and to read it. The question I might have to ask you, describe to me if a person is violating this Natural Gas Act through a restriction or a condition. What is the process for him to get a hearing on this? Now, I see in here that there is a hearing, but is this hearing after the cease and desist order, so if the guy is hanging out there, losing money, going into bankruptcy while he's trying to put himself forward to fight this cease and desist order? So I guess just take me briefly through, Bart, how a person, if my corporation violated a condition of the Act, how would I suddenly stop and have a hearing so that I would not go into bankruptcy?
Sure. Let's take Amherst. Amherst was trading on New York Exchange, Mercantile Exchange. They got too big. They exceeded their position limits, okay? So NYMEX went to them and said, you're too big. You got too much position. You can manipulate this market. And they said, fine. We'll leave your market. We're going to ICE, Intercontinental Exchange, because you can't see what we're doing. Right then and there, they knew Amherst was violating the law. And they asked them not to do it. So they said, we're going to do it anyways. We'll take our marbles and go elsewhere. And they cornered 75% of market. So here's what you could have done if you had cease and desist, but FERC doesn't have that authority. They could have said to Amrit, here's your cease and desist order. You're too big. Draw down. And now you have 10 days. This is temporary cease and desist order. We go to court. Do I have merit as NYMEX to enforce the position limit on NYMEX, on Amrit, because you've gotten too big? You have 10 days in which you go to court and lift that order if it's not there. So if I put an order, I slap an order on you saying cease and desist, stop trading, you're too big, you're violating the exchange rules, and therefore you then have a judicial review. It's no different than what Commodities Future Trade Commission has, Securities Exchange Commission has had for years. FERC has asked for this authority. I've not created something new or different.
What you're saying, you took then what the Commodities Future Trading has
Commodities Future Trade Commission has.
and the SEC has.
Right,
And you've
but
taken
that's
the same-
regulated exchanges.
Yeah.
We've created these dark markets, ICE, Dubai. They're dark markets.
So you've just taken that language that these two agencies has and overlaid it
Correct.
under the, for the Natural Gas Act, and you're making,
And to the carbon markets,
And is-
a new emerging market that we don't know yet about.
and is this identical to what is in the Commodities Exchange and the SEC?
Pretty much so, yes. We've worked with FERC. This
Can
is
I
the
ask-
language they wanted.
Can I ask counsel to confirm
Sure.
that? This might be a little difficult question for you, but Mr. Stupak is saying that the language he has in this bill is almost identical to what the SEC has in dealing with stocks and equities and what the Commodities Future has.
It's closer to SEC than the CFTC. It's closer to SEC.
Are we looking at, in his
The
amendment,
gentleman's time has expired. The council will answer the gentleman's question.
With respect to the Commodity Exchange Act, there is a provision, Section 6C, which reads, whenever it shall appear to be to the Commission that any registered entity or other person has engaged, is engaging, or is about to engage in any act or practice constituting a violation of any provision of this act or any rule, regulation, or order thereunder, or is restraining trading in any commodity for future delivery, the Commission may bring an action in the proper district court. And it continues.
Okay, gentlemen, maybe you could get another member to yield, but the gentleman's time has expired. The chair recognizes the gentleman from Michigan, Mr. Dingell.
Much enjoyed the discussion between my two good friends and colleagues here, and there's a measure of right in each. And I'd like the attention of counsel. First of all, cease and desist orders are not new, are they?
I don't believe so, sir.
And cease and desist orders may be issued before a hearing, but they must be followed by a hearing before the agency issuing them at the earliest time. Isn't that so?
Give me one moment to consult the language.
Well, supposing you take my word for it, because under the federal rules that has to be done. Now, having said that, if you don't have authority to issue cease and desist, you have to go the injunctive route. Now, the injunctive route requires the agency to go to court. That can take a significant amount of time. Isn't that right? Yes or no?
They're going to court.
Okay. So now we've got this problem. It takes a goodly while if you don't have the authority to issue the cease and desist. Cease and desist order can be issued by the agency, but it's got to be followed by a hearing at the earliest moment. If the issuance was improper, it can be lifted on application to the Commission. Isn't that right?
That's correct.
And so when that happens, they've got to do that, and the person who feels he's been wronged by the wrongful issuance of the order has a right to get a hearing at that point, doesn't he?
Yes, either before the Commission or there's also a judicial review provision.
Now, one of the reasons for the cease and desist order is that in this wonderful new world of ours, money can move with the speed of light. With electronic transfers, all of a sudden, the account is emptied, and Mr. Madoff, or whoever the rascal might happen to be, is headed for some interesting place with whom we don't have a treaty enabling us to get him back. No extradition treaty. So the argument for the cease and desist is that it gives you a quick way of getting at him, but it is a way of getting at the wrongdoer without doing it in a way which denies that wrongdoer, if he in fact is a wrongdoer, the opportunity to go into court or to go to the agency and say, this is wrong, isn't that right?
I'm not sure I can speak to the intent of the provision, but
okay, and so if he doesn't like what the agency does, he can get into court very quickly for a TRO, a temporary restraining order. Isn't that right?
yes.
So we don't need to be worried about the fact that by the issuance of the cease and desist, there's going to be any immediate calamity befalling the alleged wrongdoer who is the victim of the, if in fact he is a victim, or the defendant of the cease and desist order. He can go into court if he need to get that done, even if the agency won't do it. So he has two options to address. One is to go to court to get one is to go to the agency to get the cease and desist lifted, and one of which is to go to a court if they have not done so. Isn't that right?
That's correct, sir.
So you have here then the responsibility of evaluating how you protect the interests of a person who might be hurt. The recipient of the cease and desist order can go either back to the agency or he can go to a court and get it lifted. The cease and desist order is a much more expeditious way of addressing the matter than going into court for an injunction. Isn't that right?
I don't have specific information about the relative timing of those two proceedings.
So now we have ourselves then in a situation where it becomes useful to afford the agency the right to do this because they can't do it without a hearing, and if they play games with it, they're going to wind up in court. Isn't that right?
Could you repeat the question?
Well, and I'm running out of time here. If the agency is careless with the issuance of the cease and desist, first of all, they can't do it without giving a hearing, and second of all, they're subject to judicial review. Isn't that right?
That's correct, sir.
Thank you, Mr. Chairman.
Great. Gentleman's time has expired.
Will the gentleman yield just the rest of his time?
Gentleman's time has
I'm sorry.
expired. The gentleman from Texas, the ranking member, has indicated that he believes it is time for us to have a vote. And I know that there are members on both sides that seek to be recognized. But I think that the gentleman is giving us good advice. There are other amendments that are pending, and the next one comes from the minority side. I apologize to all of the members who are here, who I know want to speak on this amendment, but I think it's time for us to go to the vote. All those in favor of the Stupak amendment signify by the sign of aye. All those opposed, nay.
No.
The ayes have it.
Mr. Chairman, I'd like a roll call vote.
A roll call is called. The clerk will call the roll.
Mr. Waxman. Mr. Waxman votes aye. Mr. Dingle. Mr. Dingle votes aye. Mr. Markey. Mr. Markey votes aye. Mr. Boucher. Mr. Pallone. Mr. Gordon. Mr. Rush. Ms. Eshue. Ms. Eshue votes aye. Mr. Stupak. Mr. Stupak, aye. Mr. Engel. Mr. Green. Mr. Green votes no. Mr. Gett. Mr. Gett votes aye. Mrs. Capps. Mrs. Capps votes aye. Mr. Doyle. Ms. Harmon. Ms. Harmon votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Gonzalez. Mr. Gonzalez votes aye. Mr. Inslee. Mr. Inslee, aye. Ms. Baldwin. Ms. Baldwin, aye. Mr. Ross. Mr. Ross votes no. Mr. Weiner. Mr. Weiner, aye. Mr. Matheson. Mr. Matheson, no. Mr. Butterfield. Mr. Butterfield, aye. Mr. Melanson. Mr. Barrow. Mr. Barrow votes aye. Mr. Hill. Mr. Hill, aye. Ms. Matsui. Ms. Matsui, aye. Mrs. Christensen. Mrs. Christensen, aye. Ms. Castor. Ms. Castor, aye. Mr. Sarbanes. Mr. Sarbanes, aye. Mr. Murphy of Connecticut. Mr. Murphy, aye. Mr. Space. Mr. Space, aye. Mr. McNerney. Mr. McNerney, aye. Ms. Sutton. Ms. Sutton, aye. Mr. Braley. Mr. Welch. Mr. Welch, aye. Mr. Barton. Mr. Hall. Mr. Hall, no. Mr. Upton. Mr. Upton, no. Mr. Stearns. Mr. Stearns, no. Mr. Deal. Mr. Whitfield. Mr. Whitfield, no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Shattuck. Mr. Shattuck votes no. Mr. Blunt. Mr. Blunt, no. Mr. Boyer. Mr. Boyer, no. Mr. Radonovich. Mr. Radonovich, no. Mr. Pitts. Mr. Pitts, no. Ms. Bono Mack. Ms. Bono Mack, aye. Mr. Walden. Mr. Walden, no. Mr. Terry. Mr. Terry votes aye. Mr. Rogers. Mr. Rogers, aye. Mrs. Myrick. Mr. Sullivan. Mr. Murphy of Pennsylvania. Mr. Burgess. Mr. Burgess votes no. Ms. Blackburn. Ms. Blackburn votes no. Mr. Gingrey. Mr. Gingrey, no. Mr. Scalise. Mr. Scalise, no. Yeah, again. Yeah. Mr. Rush. Mr. Rush votes aye. Mr. Doyle. Mr. Doyle, aye. Mr. Engel. Mr. Engel, aye. Where is he? Oh, there he is. Mr. Pallone. Mr. Pallone votes aye. Mr. Murphy of Pennsylvania. Mr. Murphy votes aye. Who else? Anybody else?
Have all members?
Mr.
Oh, I'm sorry.
More. Mr. Mallinson. Mr. Mallinson votes no.
Have all members been recorded?
I just might ask that Mr. Barton is confirmed with Mr. Waxman, and I don't know what the margin of the vote is, but if it's within 1 or 2, he may want to escape that back room where you have him kidnapped, bound and gagged.
Who are you talking about?
Mr. Barton is on your side over there.
It's not the first time.
Can you, can you get Mr. Barton to vote?
Obviously, we didn't give you enough, Mr. Green.
Is there another allocation over there that you're still working to?
Not recorded, Mr. Chairman. Not recorded, is he? Yes. Oh, I apologize. He is. He must have ducked in. All I can remember was Mr. Mr. Barton. Not recorded, Mr. Barton. Okay. Mr. Barton votes no. On that vote, Mr. Chairman, the yeas were 33 and the nays were 20.
The Stupak amendment is adopted.